So how do you build a country's legal system from the ground up? You'd think most nations have a pretty clear story, right? But for Singapore, a place that's now a global powerhouse of trade and law, that story was for a very long time a really complex and fascinating puzzle. And today, we're going to piece that puzzle together.
I mean, just think about that for a second. Imagine trying to build a massive skyscraper, but nobody's 100% sure what the foundation is actually made of. Well, that was pretty much the situation Singapore's legal system found itself in for decades. And the big question we're diving into today is how they finally solved this foundational mystery.
Our guide through this legal labyrinth is a really important article from 1990 by the legal scholar Andrew Pong Boon Long. And what's amazing about his work is that it didn't just describe the problem. No, it laid out a blueprint for the solution. It essentially predicted the very changes that would later come to define Singapore's entire legal future.
So what exactly was this puzzle? Well, to put it simply, after independence, Singapore inherited this huge body of English law. The problem was, nobody could say with absolute certainty which English laws applied, why they applied, or even when they started applying. And look, this wasn't just some dusty academic debate. It created real-world uncertainty for businesses trying to sign contracts and for everyday citizens who were just seeking justice.
Now, to get our heads around all this confusion, we first have to understand how English law flowed into Singapore in the first place. The best way to think about it is like three separate pipelines, each carrying a different stream of law into the country's legal system.
Okay, so the first and biggest pipeline was something called general reception. This happened because of a key historical document, the Second Charter of Justice of 1826. Then you had the second pipeline, specific reception, where Singaporean laws would literally pick and choose certain English statutes to adopt. And the third was imperial legislation, which was pretty straightforward. Laws passed in London were just extended to the colonies. The trouble was these three channels didn't connect very well. Instead of a clear, clean stream, they created this turbulent, messy legal environment.
And that brings us right to the heart of the puzzle. These different channels, especially those first two, just didn't fit together neatly. They left these huge, unanswered questions that really plagued lawyers and judges for generations.
Okay, let's start with the first big headache, the cutoff date. That Second Charter of Justice in 1826. Think of it like a snapshot in time. Generally speaking, any English law that existed before that date was imported into Singapore. But what about all the laws passed in England after 1826? Nope, they weren't automatically included. So right away, you've got this fixed and increasingly old pool of law to work with. And just when you think you've got it, it gets even more complicated. You see, even for those pre-1826 laws, there was a massive catch. They only applied if they were suitable for the local conditions in Singapore. An 18th century English law about land might make zero sense in a multicultural port city in Southeast Asia. But who got to decide what was suitable? The courts did, one case at a time. You can just imagine the enormous uncertainty this created.
Now, to try and solve that problem of the 1826 cutoff, especially for the business world, Singapore had this little thing called Section 5 of the Civil Law Act. The source article calls it infamous, and for good reason. It was basically a living pipeline, letting Singapore continuously import English commercial law so it could stay up to date as a global trading hub. Seemed like a practical idea, right? Well, in practice, it was a legal nightmare. And the chaos this caused is just perfectly illustrated by how the courts came up with two totally contradictory ways to even apply Section 5. On one hand, you had the transaction approach. This was flexible. You'd look at a business deal and decide if it was the kind of deal that should use English law. But it was wildly unpredictable. On the other hand, you had the statute approach. This was simpler. You just checked if the English law itself was a commercial one. But this could accidentally import whole English laws permanently. You could literally get two different answers to the same legal question depending on which judge you got.
So, the system was tangled. It was uncertain. It was full of contradictions. How in the world do you untangle a mess like this? Well, as it turns out, the article we're looking at offered a remarkably clear and elegant blueprint. The proposed solution was just a masterclass in clarity. Step 1, pass a single new law to replace all the old confusing rules. Step 2, officially declare 1826 as the cutoff date once and for all, ending that whole debate. Step 3, create a definitive list, an actual list, of which old English laws were still suitable and would still apply. And finally, to fix that whole Section 5 mess, reenact the most important English commercial laws as Singapore's own laws. The goal was simple but revolutionary. Turn a system of inherited confusion into one of deliberate, homegrown clarity.
And you know, this wasn't just about legal housekeeping or tidying up some old rules.
These technical fixes were all serving a much, much deeper purpose. This was about Singapore forging its own distinct legal identity, free from its colonial past.
The author uses a really powerful word for this, autochthonous. It's a bit of a mouthful, I know, but it just means indigenous, or grown from its own soil. The goal was to stop borrowing and to start building, to create a legal system that was uniquely Singaporean, tailored specifically to its own needs and its own values.
And this is probably the most important takeaway of the whole thing. By finally, clearly defining which parts of English law formed its foundation, Singapore could turn that foundation into a stable springboard. It gave them a solid base to jump forward from and develop their own laws instead of being a heavy anchor permanently tying them to England's legal past.
And we'll end with this really powerful quote from the source article itself. It just underscores how incredibly fundamental this puzzle was. For a nation that's built on the rule of law, resolving these basic issues wasn't just a nice to have, it was absolutely essential. And it kind of makes you wonder, doesn't it? What other invisible foundations are the systems we rely on every single day really built upon?